As the Supreme Court continued proceedings on the Practice and Procedure Act, it became clear that there are two main things that the law does. The first thing that the law does is regulate the practice and procedure of the Supreme Court. The second thing that the law does is create a right of appeal against judgments of the Supreme Court handed down under Article 184(3) of the Constitution or the Supreme Court's original jurisdiction. As regards the practice and procedure of the Supreme Court, the law says that a committee comprising of the Chief Justice and the two senior-most judges will constitute benches. Under the Supreme Court rules, however, the Chief Justice has the power to constitute benches. What the law does is it takes away this power from the Chief Justice and it gives it to a committee of 3 judges, including the Chief Justice and the 2 senior-most judges. It was argued before the Supreme Court that if any such reform was to be brought to the power of the Chief Justice, it should have been brought through an amendment to the Supreme Court rules, and it could not have been done through an act of Parliament. The rationale for this is that Parliament cannot regulate the inner workings of the Supreme Court. Parliament cannot in and of itself take away this power of the Chief Justice, and if any change was to be brought, it ought to have been brought through an amendment to the Supreme Court rules. And if Parliament is allowed to regulate the inner workings of the Supreme Court in this manner, it would infringe on the separation of powers and the independence of the judiciary, because it would be one branch telling another branch how to do their job and the manner in which they should be doing their job. And tied in with this question of the separation of powers is Section 7 of the Act, which says that an application for interim relief shall be fixed within 14 days of it being filed. And on this, Justice Muneeb Akhtar said that if Parliament is allowed to regulate the Supreme Court in such a nitty-gritty manner, it would make the separation of powers an illusory concept. It would also mean that if there are potential for further parliamentary intrusions in the workings of the Supreme Court in the future. And on this, a lot of the judges said that, well, we're not concerned with the future and we're just concerned with the law that is before us. But the response to this is that it's a matter of principle. Does our Supreme Court, as a matter of principle, accept that under our constitutional framework, Parliament can regulate the inner workings of the Supreme Court in such a manner? And if it does, it will pave the way and it will open the door for further parliamentary intrusions. So the Supreme Court will need to answer that whether they concede onto Parliament the power to regulate the Supreme Court in the way that they've tried to do through the Practice and Procedure Act. The second aspect of the law is the right of appeal which has been created. The law creates a right of appeal against judgments of the Supreme Court handed down under Article 184(3) of the Constitution. The Constitution, however, only contemplates a review against judgments of the Supreme Court. The Constitution does not contemplate an appeal against judgments of the Supreme Court. And Parliament has effectively, through ordinary legislation, created a jurisdiction which does not exist under the Constitution. And if Parliament wanted to create such an appellate jurisdiction, it should have done so through a 2/3 majority and through a constitutional amendment. Reference was also made to entry 55 of the Federal Legislative List, which says that Parliament can make laws enlarging the jurisdiction of the Supreme Court as is expressly authorized by or under the Constitution. So entry 55 of the Federal Legislative List also supports that laws can be made only to the extent as is expressly authorized by or under the Constitution, and the Constitution does not authorize or even contemplate a right of appeal against judgments of the Supreme Court. And Parliament has done through simple legislation what required a constitutional amendment. Tied in with this question of the right of appeal is the finality of judgments of the Supreme Court. And what the new law does is it gives a retrospective right of appeal, and it says that even decisions prior to the commencement of the Act can be appealed. And this would mean that decisions given under Article 184(3) decades ago can now be appealed under the new law. And this would erode the finality of decisions of the Supreme Court, and it's in the interest of justice that there is an end to litigation, and this retrospective right of appeal conflicts with the fact that there is an end to litigation. So quite a few questions were raised and arguments were made before the Supreme Court regarding legislative competence, the independence of the judiciary, and the finality of decisions. And at the next date of hearings, it will be for the respondents to argue, and they will be arguing in support of this law.